I am presenting this very important topic because I found over the years, through my own experience in practice and in association with Professor Abdullah's and the center, that this is perhaps one of the most important aspects of Islamic planning or finance, and an area which is very, very neglected, and one which becomes very, very contentious, especially when issues of money is involved and there is no direction as to how the money is to be spent or distributed. And as you can imagine, that estate planning is not only having a will, but it covers a variety of different aspects of finance. And tonight I want to concentrate on the first one, which is wills and inheritance, and then follow up with 4 other presentations, of course not tonight, but over the next few months, like taxes, trusts, superannuation, and powers of attorney, and so forth. Because I think that these are essential elements of financial knowledge which each one of us should have and should be in possession with. Tonight I want to concentrate on 2 aspects. The first is the aspect of wills, and I've broken it up into 2 sections. The first one deals with wills as they contemplated in Australian law, and the second part would be concentrating on the Sharia aspect of wills, because the 2 together cannot be read in conjunction, so I've conveniently separated the 2. The first part, as you can see, I say that it's a very delicate balancing act, because in this aspect of wills, which is the last document that you and I will leave before we leave this dunya or this world. And there is a common saying that you cannot govern from the grave, meaning that once you go, you cannot say, oh, I should have done this, I should have done it. It's too late. So we have to be very careful in our lifetime to ensure that we don't fall in a trap of not having a will, because as I'll explain later, it does create a lot of problems, not only for you because you're gone, but for the people succeeding you, and especially for the beneficiaries. The complications are not easy sometimes and may drag on for years and years. As you can imagine, there are certain very famous cases in Australia where wills have not been, or estates have not been wound up for up to 20 or 30 or even 40 years, would you believe? And of course, in the meantime, there are beneficiaries that are denied the benefit of the estate. However, I say here that if you get it wrong, then you have a problem. You can get it right here. So there are various reasons why we say that you have to have a will in place. The first reason, of course, is that if you don't have a will, then by virtue of the law, then you die what we call intestate. You don't have a will, you have an estate, but you die intestate. There's no will. So what happens if you don't have a will? Well, then the law will say that we contemplate that because you did not leave a will, we will distribute the assets in applying to Australian law. Of course, when we say that the Australian law will apply, remember that each state has its own laws governing succession, governing distribution of assets. So if you're in South Australia and you die here, then the laws of this state will apply. There are many reasons why one should have a will. I'll just jotted down a few. A will saves a lot of unnecessary problems and inconvenience. I know personally from a very, very young age when I went into practice practice, and this family that I knew very well, quite a wealthy family, the father did not leave a will, and it's almost about 40 years, and the estate has not been fully wound up. And I'm referring here to a Muslim family. And the brothers and the sisters are split, as you can imagine, all sorts of problems. So a will should leave absolutely no doubt. If you do have a will and you want the will to express your intentions, then you must express it in those terms that everybody understands, without creating problems or doubts. One can have prepared wills, or one can resort to an Islamic will, which I'll come back later to. But the best thing is to have a will and to go and see someone who is quite an expert in drawing up a will, and who will guide you as to how best to plan your estate. Will also has a lot of advantages because it enables faster grant of probate, and that is of administration. Now, there are certain very basic elements of a will. The will is a legal document, and as such it is a unilateral contract. I say unilateral contract because it is one of two occasions when a person makes a contract. In the ordinary course of business, a contract is always between two or three or multiple parties. On two occasions, a contract can be unilateral. One is when you make a will, because you are the person. And once you have a will, then the law is obliged to follow that will. The second one is when you beneficiate something, when you leave something to someone through a trust. You establish a trust, so that's a second aspect where you have unilateral advantage of creating a contract which can be enforceable in law. So before you draw up a will, think very carefully. What are your intentions? What assets do I have? Who do I want to leave it to? Do I want to leave it in separate estate? Do I want to give X, Y, and Z X amount and ABC some other amounts? Australian law does not prevent you from distributing your estates the way you wish. However, in saying that, there are many cases where people have left their estates to animals. Now that is invalid in law. You cannot say that I will leave my estate to a cat. It is not possible. You therefore have to state very carefully what to leave, the distribution, the beneficiary, and how much to give each other. Please understand, I'm not talking about Islamic wills yet. I will come to Islamic will, but I'm talking about wills in general. Because if you don't have an Islamic will, then the laws of the country will prevail. So Islamic wills have specific rules, which I'll come to later, and you need to have someone that you can trust, that you can go to and discuss the aspects of your will. And of course, the person who makes a will is called the testator or the will maker. Usually we refer to that person as a testator. Your will must be in writing. You cannot say to someone, I'm leaving this and that to the other and recording on a tape recorder. It does not work. It must be dated, very, very important. Why? Because you may have a number of wills over your lifetime. The last will that you make, if it's dated, that is the one that will prevail. It must be signed by the testator in the presence of at least 2 witnesses. And the quality or the character of those 2 witnesses might be such that they are of sound mind as well, of course, and the testator himself or herself. And then it is very important that when you have the will document, sign every page, because it's it may lend itself to corruption. Why I say this is because if you have a 10-page will, if the pages are not signed individually, somebody can conveniently take out page 4 or 5 and slip in another page or pages. So it's important. And then makes absolutely sure that if A and B are the witnesses, that they are not the beneficiaries in the will, or they do not in any way benefit from the will. Otherwise it will be a void will. And the same pen rule. Now this is very important. Same pen means if the 3 of us get together and I'm signing my will, then all 3 of us should sign with the same pen. Why? Because if I were to take my will and give it to witness A and witness B, and they use a different pen, it can be contested because you haven't signed that will in the presence of those witnesses. And therefore, anyone can bring a document and say that, well, this was signed by the testator. Well, it's not, because it's not signed by with the same pen. And a lot of wills have been found to be void only because of this negligence. Also, be very, very careful that when you have a will, do not make reference to document A, B, C that is here, there, and another, because the will itself establishes your intention, not document A, B, or C that's just lying with someone else. So everything must be in one document. The person who makes the will, the testator, must be of sound mind. Islamic law has very, very severe restrictions on who can and who cannot make wills. For instance, someone who is mentally incapable of exercising his or her intention. And also someone who's relatively young, or a person who is almost on the sick bed and you want that person to make a will. So be very careful about that. And I'll come across an actual case where a case went to the Supreme Court to be decided, and it was an Islamic will, and the will was found to be lacking in substance, in the sense that the testator was not in her proper mind when she signed the will. You can, if you wish, engage a lawyer or an accountant or financial planner or anyone for that matter to draw up your will. However, you should remember this, that if there is no valid will, then the law of the people or the law of the state will prevail, and your asset may not go to the person or people that you intended it to go to. You can change your will at any time. You can change your will any number of times. However, and again, if it's dated, every time you change it, then the last will be the one that will be considered. If you make any changes to an existing will, that existing document must be as if it is the same as a will, signed by the testator, witnessed by 2 or more witnesses, dated, signed, all the relevant conditions. It is called a codicil, and it must, very important, it must be attached to the original will. And the codicil must say that this is a codicil to a will that was made on 20th of May, and so forth. So all the documents must cross-reference each other. If you have too many changes to a will, then it's better that you just start fresh, get a new will, because it becomes very messy later. In Australia, anyone over the age of 18 can prepare a will, provided they have what we call testamentary capacity.
Testamentary capacity is anyone sitting here or outside who has some knowledge of making a will. Of course, if you don't have any asset, there's no point in making a will. But as you'll see, the Prophet ﷺ said that if you have any asset, and any asset means even a ring, that is also part of your asset, and you must leave instruction who that ring is going to go to. We would think that, well, it's only a ring, but no. As small as it is, it has value, and you will be asked to, answer for how you dispose of your money or your wealth. You also have the problems of invalidity. Invalidity means that someone who has dementia or is incapable because of some physical inability to sign a document, then it creates a problem. However, there are cases where people who are quite normal and healthy at one point in time, and then they meet up in an accident and are severely disabled. Is it possible for those people to make a will? Yes, it is. They can express their intention in the presence of 2 or 3 or 4 witnesses. Someone who has knowledge of a will must then be there to record that, and it must be signed. If you cannot have it signed, then at least have it thumbprinted so that it establishes the authenticity of that document. Elderly people are the ones who are most vulnerable to forgeries, and that is why the law is very, very strict on how a person has come to sign a document. And very often, quite often I would say, people leave it to the last minute. I'm going for Hajj tomorrow, so I prepare my will today. Well, you had 60 years to do it. Why do you want to do it now? Your will is so important that, and the hadith will come later, showing that the Prophet ﷺ said 2 nights should not go by and you haven't prepared your will. So sometimes it is necessary when a person has some physical or mental incapability to have a doctor's statement saying that I, so-and-so, who is the private physician or doctor of so-and-so, I know this person, and in those terms say that I know the incapacity, and therefore I attest that they have made the statement, so that no one can come later and contest it on the basis that there was insufficient proof that that person had signed the will. If a will is already in place, then it is essential to update it. If you have a will in place, look at it all the time. You have a will now. Tomorrow you buy a property and you buy shares in gold coins and whatever. So you need to update your will all the time. And you need to update it because of birth or death of children or spouses or dependents, divorce, separation, disputes with beneficiaries. This one here, death of the executor. The death of the executor, if you replay, you have a will, your executor is so-and-so, but that person dies. So you must replace that executor with someone else. Otherwise, when you get to the time where you have to appoint or get the letters of probate, at that point in time, you will have a lot of problems because the executor there is not there anymore. Major changes in assets, meaning that if you establish a will today and after 2 months you buy a lot of other assets, then those assets must necessarily be accounted for in your will. Generally, a will is cancelled upon marriage or remarriage, except that in a will in contemplation of a marriage, I'm contemplating to get married. It's not true. But if someone is contemplating to get married and they make a will such that they express in the will that I bring into the marriage X, Y, and Z assets, and these assets are mine, and my wife's to be, her assets are separately, right? We call this in community of property, assets that are commonly held. Or you hold those assets in your own name. By the way, a lady who is about to get married, and she has assets. She's under absolutely no obligations to bring her assets into the common estate. What is hers, and she can by design have her own will and state how her assets are to be distributed. In most cases, a divorce does not automatically cancel a will. It only cancels the distribution to an ex-spouse. Very important this year. And a will can cancel appointment of an executor or the trustee or guardian of the kids. Now, what if you have a will in place? Well, the first thing you do after you've signed it and witnessed it properly, put it in a sealed envelope. When I say a sealed envelope, just don't put a sticky tape over it. Usually, and this is the best method, is to get the wax sealed, drop a few drops on there, and you know that that's sealed. If anyone opens it, then you know that it's been tampered with, all right? And then, you know, sometimes you have a will and you take the will and you hide it away. How do people know you have a will in the first place? So you're going to tell someone who is trustworthy, right? Don't leave it in the hands of who do you trust there? Don't leave it in those guys' hands, because you really don't know how trustworthy they are. You can easily substitute somebody's will with another will. Or, don't ever trust these guys here. They'll throw you over the... Anyway, if you know someone, and someone trustworthy, that person should also not go about and reveal to someone else that, look, I have so-and-so's will in my possession. So, bottom line is, get someone very, very trustworthy with whom you can leave your will. Then, if death occurs, the will say who is to be appointed the executor, because in the will itself it will state who the executors are. And it is the job of the executor to distribute the will in terms of the will. The executor's job is to manage the legal and financial affairs of the estate and to obtain a grant of probate. He or she must locate all the assets and identify the assets, and then, if necessary, liquidate the assets. I say liquidate the assets because sometimes you can leave the assets and distribute it, what we call in specie. In specie means that I leave this property for my son and 2 daughters, so we leave it in specie. Okay, and at other times, you say, well, I don't want that to occur, rather sell the property, take the proceeds, and distribute the proceeds. So this is what we mean by liquidating your assets. What you have to do, and I'll come to this, paying your outstanding debts, and as an executor's job is to defend the will. If there is a contestation, or if somebody contests the will because of some problems, then it is the executive's job to contest that will or to defend that will. And of course, in doing so, the executor maintains the integrity of the will. Grant of probate. this is essential. As soon as a person dies, all his assets are frozen. So don't think for a moment that somebody's died at 10 o'clock this morning, I'll go quickly to the bank and withdraw the money. Yes, you can if you are a joint account holder. But if by some sleight of the hand you go and you withdraw that money, that is illegal and you can come into a lot of problems. The public trustee is usually the one that is in control of your assets as soon as you die, until the letters of probate has been issued. And the letters of probate are usually awarded by the Supreme Court, and the Supreme Court will then appoint the executor. And you have the situation where an estate is not really worth much. Generally, if the estate's assets are less than $20,000, then the law will not require you to go through the probate process. You can distribute it, or the executor can distribute it himself or herself. And of course, where you have a problem with an executor is dead, or is no more there, or he's left the country and emigrated to another country, then you have to have what we call letters of administration. Of course, it's not an automatic procedure. You still have to go through the court process. And until such time, it's the public trustee that will have control over your assets. Now, one might think that why is it a public trustee? You see, even in the time of Umar radiallahu anhu, when we had problems in the distribution of estates, it was the Bayt al-Mal that was in charge of his or her estate until it was liquidated. The grant of probate can be avoided in a number of ways if you structure your affairs in such a way that you hold assets jointly, especially the common home. If you have a house and you hold it in the name of yourself and your wife, upon your death, it will revert to the surviving spouse. However, Islamic law comes in, and there are a few issues that I'll deal with later on, where Islamic law does not recognize the automatic acquisition of the share of the spouse, because it must form part of the common estate. So if the wife and the husband have joint control over assets such as a house, money in a bank account, assets such as gold coins, real estate, and so forth, and provided that it is held jointly, not as joint tenants, then by virtue of the Australian law, it will pass to the next spouse or the surviving spouse. In those cases, you don't need a probate. Now, not all assets form part of the estate. The assets that do form part of the estate are those that you control or are in your name personally. I have a banking account. Nobody else is the joint owner of the bank account. Therefore, that bank account forms part of the estate assets. Non-estate assets are those that are held through different entities. For example, bank accounts, joint owned properties, but also assets that are held in trust. You created a trust, you've put all your assets in that trust, and by virtue of that trust being a legal entity, it does not form part of your assets, even though you have donated or gifted those assets to the trust. Superannuation account, and here, if any one of you sitting here has a superannuation account, make absolutely sure that you nominate a beneficiary. If you don't, then it will fall into the common estate. As the same thing with the life insurance. In fact, any type of insurance that you have, and you haven't stated that who the beneficiary is, it will form part of the estate assets. So, but more important is this one here, assets in a family trust. These are very, very good assets to hold your assets, and those assets can be in that trust permanently, and your beneficiaries can benefit from those assets, even though the assets are not held in their name. What is the difference between joint tenancy and tenancy in common? The first one is where both parties own the entire assets, as in a family home. And on death, property assets passes to the surviving owner, and therefore does not form part of the estate. And then tenancy in common is that each party owns a separate or defined portion of an asset. For example, we have this property here, and 4 of us are partners in that property. So we have tenancy in common. Therefore, the property itself cannot form part of my estate. Yes, 1/4 of that will form part of my estate. So we have to be very careful about that. And then, of course, if you have shares in companies, shares in unit trusts, that forms part of your estate as well. What are the rights of the beneficiaries? The proper administration. The beneficiaries must be, they have to be satisfied there is someone there who will properly administer the estate. They will distribute in terms of the will, that the executor has no claim or assets or income, even if entitled to a bequest. I'm saying this because a beneficiary cannot benefit from an estate until the assets have been officially gifted to the beneficiaries. Until then, it does not belong to the beneficiaries. Now, very, very common problem is that beneficiaries think, well, my father or my mother left that house for me, therefore I'll take that house and I'll go to the bank and I'll raise a loan. You cannot do that. There are cases where you can challenge the validity of the will. One is that a person does not have intellectual capacity, or does the grantor beneficiary may contest it under 3 conditions: that there is lack of mental condition there, undue influence. Some people has gone and influenced the testator, and made sure that the testator has nominated someone other than people that should benefit from the estate. And then, of course, incorrect execution means that there is problems with the legal document itself. Perhaps it is not properly dated, perhaps it's not properly signed, and so forth. The court will be, if the court is unable to validate the will, it may look at an earlier will if there is one, and if none exists, then it will revert to what we call the laws of intestacy. The laws of intestacy simply means that you have died intestate. Then the second type of form of contesting a will is one where there is legally proprietary. The potential claimants, family members or former spouse, can contest the will, but the state laws may define who is a claimant. So if no one of us can just go and say, you know what, I have a claim to that estate. You have a claim to that estate only if you are considered to be a proper claimant. And therefore, if you think that you're going to have a problem, now commonly, if a father or mother has, say, 5 children, and that person wants to exclude one of the children, Australian laws are very strict. They can contest it on the sense that it is not fairly distributed. So what a lot of people do is that they leave a small amount for that person that they want to exclude. And therefore, by virtue of that clause there, that person is excluded. However, there are cases where the court has overturned such a provision. Here is a case of a lady called Miriam Umari. She came from Kurdistan, and she was very young when she got married. She came to Australia, and her husband left her. There was a divorce, and over the years she acquired a lot of properties in her own name. And then she was later in her later stages of life, she developed dementia. But the two sons that were in charge of her estate saw to it that they wanted her to make a will, and she insisted that the will must be an Islamic will. However, when she died, the daughter and two other sons approached the court and said, well, you know, this will that she made, even though she expressed it in front of many witnesses, is invalid. And it was invalidated because she signed it while she was in a state of dementia. And it was very, very difficult to prove that she was under that condition. However, the public trustee went back to find if there was a doctor or specialist, anyone who knew her condition. And they did find that there was someone who could attest to her mental condition. On that basis, the will was set aside, and her estate was then considered intestate, and the laws of the land prevailed. In other words, her wish that it be distributed in terms of Islamic will was not fulfilled. I'm not going to go through this, but it's a lengthy. As you can see, this was a case that goes back to 1870. And this judge set out the conditions. And here it says that no insane delusion shall influence his will in disposing of the property. That is the clause that always applies when a estate is being contested. Intestacy is when you die intestate. I'm not going to go through this one because it refers to the rules in Victoria. However, the rules in South Australia are simple. If there is a surviving spouse, the first 100,000 in the estate will go to the surviving spouse. If it's 100,000 or less. If it's 100,000 or more, then the first 100,000 will go to the surviving spouse, and the balance will be distributed to the other the beneficiaries. If the surviving spouse dies 28 days from the date of death of the dead spouse, then he or she is excluded. If there's no surviving spouse and children only, then the children must share equally. Adopted children must prove that they are lawful children. Illegitimate children are excluded, or stepchildren are excluded, unless it is specifically said. However, you cannot say that because it's intestate. There is no will, and therefore they are left out. So if the surviving spouse or the child has some other, if there's no surviving spouse, no children, then it will revert to one of the siblings of the deceased. If there's no siblings, if the law cannot find anyone that is closely related to the deceased, then in very extreme circumstances, the whole estate will go to the state. A common belief is that, if I die intestate, it will go to the state. It's not so. We're shaking hands here, of course, but here Islamic worlds, and the Quran makes it very, very clear that Surah Nisa is what is commonly called the Surah of inheritance. All the laws that you need to know about inheritance are in Surah Nisa. And Surah Nisa also explains the rules pertaining to inheritance, the proportions of the shares of entitlements, and who are the beneficiary and in what percentages. If you want someone to inherit from your estate, you must make and have in place a will, or what we call wasiya, that is compliant, I mean Sharia compliant. Allah's Messenger ﷺ said, it is not prudent for a Muslim person who has something, when he said something, anything, he wants to give as a bequest to have it for 2 nights without having his will written on it. So you can see this is not something that is said lightly. The Prophet ﷺ himself said it, so we should be very, very clear on that. And of course there's this other hadith where the Prophet ﷺ said, if a person has done good deeds, everything during his life, but he hasn't left a will, and he was so negligent that we can say that he was wicked in his intention, then the hellfire is his abode. Of course, there are various different types of proportions in which the estate has to be split, and I will come to that later in the next few slides. If you choose not to have a will, then you die intestate and the law applies. If you have a will, then you can exercise freedom under Australian law. You can dispose of it whichever way you please. Best thing, if you want to, you can have an Islamic will. However, if you have an Islamic will, you have to be mindful that the Islamic will has rules that are different from Australian rules. The executor has to collect all the assets. He or she must pay all the funeral costs. If there are legacies, if you say so much must go to the masjid or the madrasa or something, that must be given out, and then whatever that person has set aside, he said, I want to give kafara for whatever, that must be paid out. The balance is what we call the residue. The residue must then be distributed. How do we distribute it? If there are joint tenants in this case, a husband or a wife, under Australian law, because it's held jointly, you can bypass the will. It goes straight to the surviving person. However, if it's in Islamic law, it must be included in the distributed assets. Commonly, what will happen is you allow the assets to be to pass into the surviving spouse, and then what you do is to estimate the value that that spouse has acquired, and then bring that value in the estate. Tenants in common depends on how you elect. Let's say a sharing property. The deceased's share falls into the estate, which is the same as in Islamic law. Superannuation and insurance, these are assets that can pass immediately to the beneficiary that are stated in the insurance or the in the superannuation. However, remember that because they pass to the surviving spouse, it doesn't mean you have absolved yourself of the obligation under Islamic law, because under Islamic law you have to bring those assets back into the estate and regard it as part of the estate. Then who inherits and how much do people inherit? To read this, there are 2 different blocks here. This block here and this block here. You first go to this block here and say, are there any children? If there are any children, then a parent gets 1/6 each, mother and father. If there's a husband, he'll get a quarter. If there's a wife, we'll get 1/8. If there's a son, the son will get 2 times the share of the daughter. If there are daughters only, 2 or 3 daughters, then 2/3 will go to the daughters, split equally. If there's only 1 daughter, then she will get half the estate. If there's no children, then the mother will get 1/6. However, the mother will get 1/3 if there are less than 2 brothers. If there is a husband, there's no children, then the husband will get half, the wife will get a quarter. If no father, then a grandfather or brother will acquire the assets of the estate. I must tell you that it is not as simple as you see it here. It can be complicated because you have children and stepchildren and so forth. But here is just one aspect of how an estate can be distributed in terms of what the Quran says and what the Prophet ﷺ has set out. I want to thank you for listening. The next set of presentation that I hope to do will deal with retirement planning and how to plan your affairs, financial life cycle investment strategies and so forth, how to build up your assets, how to make sure which assets fall in the estate, which fall out of the estate and so forth. So as I said in the beginning, there's about 5 different aspects of estate planning. This is just part 1. I hope that you can come and listen to parts 4, 3, 4, 5, and 6. Thank you very much. Assalamu alaikum.
All right, Jazakumullah khair, Dr. Mahmoud Nati. As you can see, not only is it important, but it can also be complex. I think what is important to note from the presentation that Dr. Mahmoud gave is that, one, the importance of having a will. Whether you are thinking of an Islamic will or a will generally, a will is necessary, especially if you want to determine how your assets and estates need to be distributed. But given that we are Muslims, of course, having and to understand how to write an Islamic will is very important. And I know there wasn't much discussion on that tonight, but perhaps that could be for the second lecture. I think the emphasis today was on having a will, and if you don't have an Islamic will as such, where will your money go? Where will your estate go? Where will your assets go, and how will it be distributed? And despite the fact that both the state or the government and Islamic law both advocate for having a will, there are some slight and significant differences that we must be aware of. So now what I want, before opening the floor for Q&A, the next month's lecture was meant to be my lecture, but I'm going to forfeit that. And I want to propose that actually Dr. Mahmoud carries on with the theme, so that at least everybody who's here can come back again and follow with this theme. I hope you agree with that. I will cancel my lecture at no cost. So, my pleasure. But I think it's such an important... I put in my will. No, you put in your will to give me some shares of your will. So the point is, there is a theme now going, and I think it'll be important if Dr. Mahmoud was to carry on this theme. What I would like to see personally next time is more discussion on this, and I'm sure that's what you want also. So today was a thorough discussion on will from the perspective of the common law, and specific focus on South Australian law. And I think what most, in fact, if not everybody here, would want to know, well, can we know more about this? Can we speak more about this? And this is what perhaps can be done next time. All right, so because of time, perhaps we'll allow for 3 questions. And if you have a comment, you're most welcome to make a comment, but make it short and precise, not a lecture, a comment. If you have a question, please ask your question. And again, try to be precise, concise, and inshallah, Dr. Mahmoud will answer those questions. So who would like to ask first, please?
Assalamu alaikum. First of all, I should be thankful to you for giving all these details. I have a will and I have done it through the lawyer, through a law firm. I have multiple questions related to that. Number one, related to the executor. Is that lawyer the executor, or the law firm who has the possession of my will is the executor? Number two, does Australian law understand? Sorry.
You have a will. You signed the will.
Yeah.
How is it that you don't know who the executor is?
It must be there on the will. I don't remember it right now.
You can't say it must be there. That is the point I'm making. You cannot assume anything. Because if you sign something, you ought to know what you're signing. If you say X, Y, and Z are the executors, then those are the executors. The lawyer has absolutely nothing to do with it. You, the testator, must state very clearly, it is X, Y, Z who are the executors. You cannot assume that it is there. Please understand, it's a document, legal document, it can be contested. So if you tell your wife or your children that, you know what, I've nominated so and so, and the will says, well, it's, I don't know, someone else, well, you're creating a problem for yourself.
Okay.
The
Second thing is Australian law. Do understand the Sharia law, because I stated in general Sharia law. I didn't do any distribution, and I said that my assets should be distributed according to the Sharia law. Is it understandable to Australian law as it is?
Yeah, you can say that. However, you can go beyond saying that it's Sharia law.
Okay.
Sharia law as such is not recognized.
Okay.
When you say Sharia law, you can say that the distribution of the assets must be in terms of, and then you specify the laws of Islam, all right? And specify what that should be.
So do we have any particular document that we can attach to that? Because it has different interpretations in different fiqh as well. That's the problem.
Make very sure that a will is only one document, not a series of documents.
Okay.
You will only have one will document, and that document must document every intention of yours. Right? However, if you say that your estate must be distributed in terms of the Islamic will, there's absolutely nothing wrong. You see, Miriam or Mary, her will would have been completely legal if not for the incapacity due to mental incapacitation.
Right.
Right.
And is this will applicable to my assets outside the country, somewhere else?
When you make a will, you must list all your assets here and overseas. You cannot say my will applies here and the assets I got there. And there's another will. There's only one will.
Just as a follow-up on the first question, if you don't mind, just for clarification, in case it's in somebody's mind. When you said in the will, you can say, I want my estates and assets to be distributed according to Islamic law only, without specifying. Now, will that not create some problems? Because Islamic law can be interpreted in so many different ways. And now he will be leaving the interpretation of the distribution to whomsoever the court chooses. And it might not be necessarily according to your intentions. Will there not be some complications there? If he does not stipulate, maybe, can he say, according to the Hanafi interpretation of Islamic law, for example, and then the court will have to go and look for a scholar who does know how to do that? Or could he, in the will, or she say, in the event of my death, then I want, and name the actual scholar with whom he is confident to actually distribute my inheritance according to his understanding or her understanding.
Correct. The problem with nominating a scholar is that that scholar can be here today and not tomorrow. That's all. So if you say that the laws concerning this madhab, then that is perfectly acceptable. Yeah. But you have to state there, as Professor Abdullah said, that you have to state that I wish or I will that my estate be distributed in terms of the Islamic laws of inheritance. You leave it at that. The Islamic laws of inheritance, I must tell you, are so clear that even distant relatives are covered, of course up to a certain degree of nearness. The test is how far are you away from the deceased. If you're very far away from the deceased in terms of your relationship, then the ability to inherit becomes lesser and lesser. Right? The closer you are, you go up the ladder, parents, down the ladder, children, sideways, husband and wife. Okay? If you want to go further than parents, grandparents. If you want to go further than children, grandchildren. See, that is how.
Thank you. And which is a very important point, because most people get confused about why boys get more than girls. Because you need to understand that the laws of inheritance in Islam are not gender related, but they are kinship related, relatives related, and not gender related. Right?
Thanks for clarifying that. Thanks for clarifying that.
Correct?
Absolutely.
Another question? Yes, brother.
Do you need a mic, or you have an
No, mic.
please?
Is there a template available which we can use for Islamic will, which also complies with the Australian law?
I have a very good friend in Brisbane who has a template. I don't want to give you that template unless I've spoken to him and said, look, there are people there that require a template, can I use it? And if he says yes, most certainly I can pass it over to you. However, I still recommend go through that, read every page, understand what's in there, then make your decision. If you don't understand a thing, take advice. Sometimes we are reluctant to spend $200 or $300 to get advice. That is where you get into problems. Good advice comes at a price. I don't say you must spend $10,000, $15,000, not at all. But take good advice. Even though you have a will that has been used repeatedly.
And if he does want to take good advice on how to write an Islamic will, where can he get that advice from? I'm an advocate, you see.
Right. There's a number of people, but I don't want to sort of disclose here.
The obvious question is, will you assist? I mean, that's what some people may be thinking, right? Are you a person who might advise?
Of course.
Or are there people
I'm
that
getting
you-
paid.
Pardon?
I'm getting paid those $300 or $500.
And give it to the center.
Inshallah, I hope in my lifetime to do a service to people and give them some form of advice wherever I can. However, there are some instances where, you don't exceed that.
Excellent. And I'm just trying to be practical, I guess. So Dr. Mahmoud Nati is part of the center. I would probably say maybe feel free to email him for maybe to get further clarifications or directions, or he may point you to some people. And if you want that template, write to him so he can seek permission and pass on the template. One more question? Yes?
If anybody wants to make a will, you mentioned that he should be present with two witnesses.
Two or more.
Two or more. Okay. But he don't want to show them the will itself. They want to sign that this is a will, and I sign in front of them, and this is, I'll close it and seal it. And they will sign that, okay, they are witness for the will. Is that applicable? And I will keep it somewhere.
So what you say, you want to hide the contents of the will
Yes.
from the witnesses.
For example, yeah.
Okay. Let's suppose the will has problems, and this will is contested, and it goes to the court. The court says, okay, bring the witnesses, and the witnesses say, you know what, I was just given this thing to sign. We have a problem. you just can't sign any document unless you know the person could give you any document and say sign here. So I'm saying that look, don't be so naive to think that if I disclose everything to the witnesses that they will go and they will, you know, use this information. I know exactly the concern you have. Yes, the witnesses are there to witness that you, the testator, has signed. That is all. They don't need to go through the details of what's in the document. But you have to be absolutely sure that those witnesses are trustworthy people who can attest later that yes, I did witness this. Problems also arise when the witnesses are not there anymore. And in the case of the Miriam Umeri, there were 2 witnesses there. The problem was they had 3 wills signed there. And when they signed the wills, they didn't sign it in the order in which each one had placed their signature. So when it went to court, the judge said, well, hang on a second, look, I've got 3 wills here now. Which of the 3 wills is genuine? So don't go and make 3 or 2 wills. 1 will is suffice, that's it. You can't read the same thing 3 times over. So 1 will, and that is a will that will prevail.
I was just wondering, is it possible that the Center of Islamic Thought run consultancy, like for wills, like professional consultancy?
You asking me, you asking him?
Anybody?
I have authority over that. He's the expert, but I can make that decision. Sorry. We could do professional, you could make it under professional development, and you can charge for it, right? So it'll be like an executive program, a short executive program that is specifically tailored to educate participants on everything to do with wills and help them also perhaps write wills. And that can be at a cost. So yes, that is possible. Yes, Center Manager, see? Excellent. Is that it?
Yes, yes. I think my question has been covered. I have an Islamic will, but after listening to you, I think it is an inadequate will. And I would like to know, hopefully, after what Dr. Muhammad said, that we can get assistance from your center and pay for it and write a will that will stand in court and still be an Islamic will. One comment, I came here mainly to see, and I hope you mentioned you will talk about in future, is what does an elderly person who is about to retire do with his superannuation money so that he can invest it in and live in peace, peace of mind. Inshallah, maybe that you can comment on or tell us when you can talk about it.
You know, it's such an important issue that you raise, and that is why one of the areas that I want to cover is what I call life cycle investing. People think that I will only start planning for my retirement when I'm 60 years old, whereas the process should start at age 25 or somewhere there, so that you build up your assets. And then when you've built up your assets, we call this the accumulation stage. You accumulate the assets. Now you've reached 60, now this is what you call the decumulation stage. Now you use those assets that you've built up and you start using those assets. You know, the thing that always worries me is that, and the Prophet ﷺ said, never let your hand go out like this, as beggars do, but rather like this, give, not take. Nobody wants to be in that position where you go constantly, you're 70 years old and you go and, you know, give me money for this month. It's not a nice feeling. You're absolutely right. You have to invest your assets very, very wisely. The tendency in Australia and overseas is that you take some of your money and you put it in this asset, that asset, that asset. what we call you divest your assets across a number of assets, and you try and get a reasonable return from each one of those. Because if any one of those goes down because of economic circumstances, you can always rely on the other two. It's difficult to explain in the short time that I have how best to invest your assets, but diversification is what they call it, is the best, one of the best methods to employ your assets so that you have a variety of assets in which you have placed your money.
But how do you ensure that the assets return is halal money?
There's a number of ways you can do that. That is one of the complex reasons or complexities of Islamic finance, is to unravel that mystery. How do we make something there, or how is it to extract from the multitude of assets that are there, those that are compliant and those that are non-compliant. Inshallah, this is something that I'd like to discuss in detail. And it takes a lot of time to explain. It's not easy. You have to know some, you have to have some knowledge about the stock market, the property market, investments as such. And this is what we call financial literacy. I find that so many people have acquired so much money over their lifetime, but they really don't know how to dispose of that money or how to use it for the best intents, purposes. So our next series of lectures will, inshallah, hopefully cover all that. Also, before we part, we've had a good attendance tonight. I'd like to see it twice, 3 times, 10 times the number. Because our center here is geared for what Professor Abdullah said. We're here to share our knowledge of Islam, whether it's in education, whether it's in domestic violence, whether it's in Arabic studies of leadership, anything of that sort. If you have a problem as such, come and see us, come talk to us, and inshallah, hopefully we can provide some assistance.
Just a quick comment along those lines. I think there's a lot of people who are desperate to find a center like this, but are not aware.
Yeah.
There's a lot of Muslims in this town, and I think one simple way of raising awareness about the site is to give pamphlets on Friday prayers, and that will pass on to multiple levels, or I don't know other ways that the center might explore.
One of the best ways I found is through word of mouth. I find it very, very effective because it has what we call snowball effect. You talk to 10 people, they in turn talk to 10 others, so that you already have 100, and so on. The tendency with handing out pamphlets is this, I don't have the time yet, take the pamphlet and you throw it in. I'm not saying it's not effective, but I think that if we have more of such occasions, and we engage with people, and those people then go back and engage with others, and so on and so forth, we'll have a very big cohort of people that will start knowing what I was saying.
It was information about this seminar that brought me at least here. Otherwise, I wouldn't have known about it. And the problems I face, I can bring you 20 or 30 people next time who have the same problem. The retirement is ready, I want to rest, I want to have peace of mind, but what do I do with this money? Put it in a bank, you get interest. You put it in superannuation, you don't know, somebody will tell you it's in alcohol, it's in gambling, it's in this, and you spend sleepless nights instead of having peace of mind.
Absolutely. I think what Professor Abdullah has alluded to is that our center will set up some form of an advisory division where all these problems can be addressed. And not only myself, but I can bring in experts from other disciplines to explain exactly how it is done in practice. I can speak about this forever and ever, but I like to have someone with me say that, you know what,
we'll take your asset and we'll do this, that, and the other.
You see, a financial advisor will charge you up to $3,000. You can do the same and say, we will help you to do an Islamic financial planning and charge you.
We won't charge 3,000, just 2,999. All right. Excellent ideas. Also excellent idea. I don't think we should discount any of these ideas. Even handing out pamphlets will help. We've been here now, as I said, it will be 3 years. Every major Islamic organization knows about the center. The state government knows about the center. The media knows about the center. The masjids know about the center. But it has been difficult trying to reach the common person.
I didn't know about this.
Yeah, so which is good to know that you didn't know, because it makes us go and work harder to try to make, inshallah ta'ala, more people know about it. One thing for sure, you do know that, before you leave, write your name down and your email address so that you receive notification for the next lecture. And now you do know that the next lecture will be a continuation. And you can bring friends also with you. But you have also given us some ideas about possibly maybe a one-day workshop, in fact, that only focuses on this, where you turn up to the workshop, it will be theory and practice, and perhaps also, as Nadia suggested, perhaps some of those short executive programs. And honestly, it's not about the money, it's more about passing the information on. Centers like this don't make profit, as you know, but it's passing that knowledge and experience. In this case, it is of course Islamic finance and so forth, but as I said, the center has been working also with multiple schools across the country, Islamic schools. We are helping a lot of Islamic schools in renewal, but also now even the independent schools of South Australia. Dylan has just come today from a second meeting with them, and now they're saying they want to work with SITE and all Islamic schools on understanding the Muslim child. What we are trying to do through the center is also raise awareness among government, education departments and so forth, to, for example, in the case of Islamic schools and the Muslim learner, is how can we be responsive to the Muslim learner, Muslim child or learner, whether in an Islamic school or a public private school. And alhamdulillah, there has been lots has been done in this regard. We have a conference in July, on the 12th and the 13th of July in Melbourne on Islamic schools. This is the 4th annual conference. And also the other fields, on leadership processes in Islamic organizations, strengthening family relations, intimate partner violence, domestic violence, Arabic studies, Islamic pedagogy, and so forth. All right, so in order to, we do have a quarterly newsletter, and so inshallah ta'ala, if you put your name down, you will receive quarterly newsletter free of charge, and also you'll receive updates about our lectures. Sometimes also we receive interstate scholars or international scholars that you may wish to attend to listen to them. And I guess last but not least, by word of mouth, if you could spread the message, inshallah ta'ala, and we hope to see you again, inshallah ta'ala.